In this video, I'm going to show you exactly how Florida CEOs protect their wealth in a divorce. By the end of this video, you'll understand the legal tools that can save millions of dollars. These are the same strategies I've used with my own clients. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. Now, I've spent over 3 decades helping business owners protect what they've built. What I'm about to share could be the difference between keeping your company and losing it. All right, imagine, if you will, you built a $50 million company from nothing. You're getting divorced. Your spouse's attorney just claimed they're entitled to half of everything you've built. Now, most CEOs lose millions in these battles, but the smart ones, they use strategies most people have never even heard of. Now, here's what makes Florida different. Florida is an equitable distribution state. That sounds fair, right? Well, wrong. It means the court divides marital assets in a way they think is fair, not 50-50 necessarily, but fair according to a judge who's never built a business. And here's the thing most CEOs don't realize. Your company might be considered a marital asset even if you started it before marriage. If it grew during the marriage, your spouse can claim a piece of that growth. I've seen CEOs who started companies worth $500,000 before marriage. 10 years later, the company is worth $20 million. The spouse walks away with a huge chunk of that increase. Now, the average CEO divorce in Florida, it takes 18 to 24 months. Legal fees alone can easily hit 6 figures, but the real cost is the business disruption. Imagine fighting over company valuations while trying to run your company. Employees get nervous, investors get worried, and deals, well, they fall apart. So how do smart CEOs avoid this nightmare? Well, strategy number 1 is prenuptial agreements, but not the generic ones you download online. I'm talking about bulletproof prenups that specifically address business interests. Here's what needs to be in there. First, clearly define what's separate property. Your company shares, stock options, intellectual property, everything business related gets listed. Second, include a formula for how the business gets valued. You don't want to fight over whether to use book value or fair market value 3 years from now. Decide it today. And third, and this is critical to address, business growth. If your company triples in value during marriage, what happens? A good prenup answers this before it becomes a courtroom battle. Now, I know what you're thinking. What if you're already married? That's where postnuptial agreements come in. They're harder to enforce than prenups, but they work when done correctly. The key is both spouses need independent legal counsel. Both need full financial disclosure, and there needs to be consideration, something of value exchanged before signing. All right, strategy number 2 is where it gets sophisticated. Florida allows something called asset protection trusts. These aren't your grandfather's trusts. These are specifically designed to shield assets from creditors and divorce claims. Here's how they work. You transfer assets into an irrevocable trust before any divorce talk starts. The trust owns your company's shares. You're not the owner anymore. The trust is. You can still benefit from the trust. You can still receive distributions, but the assets aren't technically yours. Florida law gives these trusts powerful protection. If the trust is properly structured and it's been in place for a while, those assets may not be reachable in divorce. The timing matters, though. You can't move assets into a trust when divorce is imminent. That's called fraudulent transfer. Courts will unwind it faster than you can say alimony. I had a client who set up an asset protection trust 5 years before his divorce. He transferred 40% of his company shares into it. Now, when the divorce happened, those shares weren't on the table. His spouse's attorney tried to get everything to crack that trust. They couldn't touch it. That 40% stake stayed protected. Now, before I move on to the third strategy, if you're finding this valuable, do me a favor. Hit that like button right now and subscribe so you don't miss the most advanced strategies I share every week. All right, now let's keep going. All right, strategy number 3, how you structure your business determines how vulnerable you are. Most CEOs make a critical mistake. They own their company as an individual or in joint names. That's asking for trouble. The smart play: create a complex ownership structure before divorce becomes an issue. Use holding companies, create multiple LLCs, and make yourself a minority owner on paper while maintaining control through voting agreements. Now, here's a real world example. A tech CEO I worked with owned 100% of his company. We restructured it, we created a holding company, transferred the operating assets to subsidiaries, and we set up a management company that he controlled. On paper, he owned 30%. His asset protection trust owned 40%, and a family LLC owned 30%. When his divorce happened, the valuation became much more complicated. His spouse's attorney couldn't just point to a simple balance sheet. They had to unwind multiple entities, value minority interests, account for lack of control discounts, and what could have been a $30 million claim became a much smaller number. All right, here's strategy number 4. Documentation and timing can save you millions. Every CEO needs to maintain separate property documentation. Keep records proving what you owned before marriage. Track the source of funds for every major transaction. Now, here's why this matters. Let's say you started your company with $200,000 that you inherited. That's separate property. But if you can't prove where that money came from, the court might treat the whole company as marital property. I've seen CEOs lose this argument because they just didn't keep records. You also want to avoid commingling. Don't mix personal and business funds. Don't deposit marital income into accounts holding separate property. The moment you commingle, you've potentially converted separate property into marital property. Keep everything clean and segregated. Another one is timing issues. When you take distributions from your company matters. Taking huge bonuses right before filing for a divorce, that looks like you're hiding assets. Courts will impute income based on your capacity to earn. They'll assume you can take those distributions anytime. Now, here's something most attorneys won't tell you. The best protection is making yourself less attractive to sue. That means running a lean business structure where you don't personally hold assets. It means having good corporate governance, minutes, meetings, proper documentation that you're treating the business as separate from yourself. Florida courts look at whether you respected corporate formalities. If you treated your company like a personal piggy bank, they'll pierce the corporate veil. Your business protection will just disappear. But if you maintain proper separation, kept good records, and followed corporate procedures, that protection, that's going to hold up. Look, divorce is painful, but it doesn't have to destroy what you've built. The CEOs who come out ahead are the ones who planned before. There's a problem. If you found this helpful, make sure you like this video and subscribe to my channel for more strategies to protect your business. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.